Honor, on behalf of the appellant, Mr. Donald Smith, he was the defendant at trial. I would like to reserve 5 minutes for rebuttal, please.
That'll be fine.
Your Honors, this matter concerns property in Cumberland County, Tennessee. The essence of the action was with regard to a claim of ownership and control of the property by both of the parties. Mr. Smith purchased the property in approximately 2007, or he had a lease purchase agreement which allowed him to purchase the property. He was there at the property when this lawsuit was filed, but he had removed himself from the property because in the interim, his ex-wife, who was the plaintiff in this action, the Appellee, was allowed to move in. These parties had mutual children, and Mr. Smith had testified that he wanted to ensure that the children had some time to spend with their mother, so he allowed her to move into the property in Cumberland County while Mr. Smith moved and lived someplace else. But Mr. Smith did move back into the property. And again, he had, under a lease purchase agreement with the title owner, the right to purchase the property, had an interest in that property going through this action. Under the petition that was filed against Mr. Smith, the allegation was fraud. And that is because the allegation was that Mr. Smith had prepared a quitclaim deed and that it was recorded with the Register of Deeds office, and Mr. Smith claimed ownership to the property, and I submit had ownership interest rights to the property whenever he was, when this action was tried and when he removed himself from the property.
Excuse me for interrupting, counsel. With reference to that quitclaim deed, it's my recollection from the record that that deed was dated 2012. Is that correct?
That's correct.
Recorded in 17.
Yes, Your Honor.
And does that quitclaim deed include in the derivation clause a reference to a deed that was recorded in 14?
That's true, Your Honor. Number one, with regard to recording the deed 5 years later, there's nothing wrong with that. There's no limitation or waiver of right merely because the deed's not recorded. Now, of course, someone who comes in and files a claim against the property or purportedly transfers the property during that period of time would not have notice of the quitclaim deed that was being held by Mr. Smith, but it doesn't void the deed. And in this case, the deed was signed by the appellee in this action, who was attempting to remove Mr. Smith from the property. Now, with regard to the derivation clause, of course, the statute was added requiring that a derivation clause be included in a deed, as well as, and this ties into the statement of who prepared the deed. So there's no question that Mr. Smith, after he had the face of this deed prepared, he said he sought counsel and was told, I have to have the statement with regard to who prepared the deed, and that was done later, and who was it that, or what was the derivation of the title? Well, he used title to the 2014 deed that was referenced in the deed.
So your client is conceding that that instrument, that deed, was changed after its execution in 2012.
Portions were added. The derivation clause was added. The who prepared the document was added. And I'll submit, Your Honor, whenever, every day I submit at the Register of Deeds office when a deed is presented and the clerk says, hold it, I'm required or someone's required to represent who prepared this deed. Every day at the clerk's office, there's a reference. Either someone writes at the top, prepared by XYZ, or in this case, prepared by Donald Smith, the appellant, but he had it typed in, and he had the other document, the derivation clause, referenced as well. He didn't change anything. He added statutorily required elements to the document, which changed nothing with regard to the conveyance on that quitclaim deed that was made by the appellee to Mr. Smith, acknowledging that Mr. Smith had ownership interest in that property. So, and this, at that point, I mean, there's no question about that because of the dates and such. Now, I submit also.
So that's how he explains the date. Was that his testimony, that I added this afterwards?
That is my argument on what happened and why it is.
I want to know what his testimony was.
His testimony was cut off. The judge interpreted that because the dates were not consistent with what might be, what a person would see whenever what a fully prepared deed is presented to someone for execution, like an attorney would prepare.
I understand. So the argument you just made was that that's what my client would have testified to.
Yes, Your Honor.
Did you do an offer of proof?
I was not trial counsel.
Did trial
Counsel did not present an offer of proof, Your Honor.
So we have no way of knowing.
Well, but
Do we have any way of knowing what your client would have said?
which there in the record, no, except that part of the argument I'm presenting to the court today is concerning the judge's decision to remove, as he says, I told Mr. Smith to remove himself from the stand, was not allowed to testify any further on any other issue, period. So the argument is that the judge can weigh the evidence, but at least he has to hear the evidence and allow evidence to be tendered or presented. Now, if there's evidence that is inadmissible, rule that it's inadmissible. But don't summarily remove, in this case, Mr. Smith from the stand so he cannot address these particular questions that are before the court. Is it relevant? Is it pertinent? Is it important that we know that? Obviously, the court's asking that question. But if you look at the document, it's certainly, in my mind, and I submit to the court, that is a valid explanation that Judge Thurman did not take into account. He did not consider that. And as a result, that's exactly why we're here today, as opposed to there being a ruling that we'd say, well, the judge heard all the evidence and made a decision, and we may not agree with it, but that's his rational decision. But to explain to a witness that I'm not going to hear anything further from you, and because I submit the record reflects that the reason he did that was because of the dates being inconsistent with what he thought, at least on the periphery and from the surface, was inconsistent with what maybe it would be the better case scenario.
Well, I mean, you think it also might have had the trial court's lack of credibility determination might have had something to do with your now client testifying that I don't know anything about these quitclaim deeds. Gosh, I don't know anything about them. And then on cross-examination is, well, yeah, I did prepare these, and as it turned out in Florida, I prepared had six quitclaim deeds, or it wasn't 5, it was actually 6, something like that, and then laughs about it. You think that you think that might have had something to do with the trial court's determination that?
Unfortunately, we don't have a transcript. When Mr. Smith came to me, I asked him, do you have a transcript, or who was the court reporter? And by golly, there was no transcript. We had to create a statement of the evidence, which is extremely difficult. And I advise anybody today, do not take an appeal when you don't have a transcript. We went back I presented and prepared what I could prepare from my client's statement and from the information from the trial counsel as well, and from the documentation. Of course, I didn't know what was right and what was wrong in that statement. It was presented so we filed it. It was challenged. We went back to Judge Thurman. We argued issues before Judge Thurman, and we got what we got. It's crystal clear that my client wasn't allowed to testify about pertinent issues that were at the crux of this matter. And what we've asked for, Your Honor, is that the matter be returned back to the trial court if the court doesn't just overturn the court's ruling and recognize the quitclaim deed for what it is. There are a couple other issues that were addressed, Your Honor, with regard to this appeal. One a very important, very critical aspect is the damages evidence. In this case, the appellee, the plaintiff, was allowed to testify just freely about what she was asking for. And that's what she testified to, what she was asking for. Now, I submit that she made reference to, well, I've got an estimate about some matters. And objection was made with regard to her testimony concerning HVA system repair, that's heating, ventilating, and air conditioning system, the soffit and gutter replacement or addition to the house, internal construction, plumbing where pipes had to be cut and replaced, etc. This woman had no idea, probably no better idea than I would on how to plumb a house. But there was no qualification for her. She was allowed to just go through and state round numbers for whatever she was looking for, and $8,000 was awarded against Mr. Smith for alleged damages. Now, in this particular case, the property was owned and it was being leased. Now, I submit that there's no provision in any agreement between these parties that required Mr. Smith to maintain a certain level of standard at the house, and there's no evidence to suggest that he's the one that caused any problem with regard to the condition of the house, and or nothing to suggest that what the condition of the property was. I'm almost out of time, but very quickly on the attorney fees issues, there's no legal basis for an award of attorney's fees, and and more importantly, even really, there's no evidence about what appropriate attorney's fees should have been. Thank you.
You have your time for rebuttal. Hear from the appellee.
May it please the court, my name is Samantha Ellis, and I'm here on behalf of the plaintiff appellee Nikita Thomas. At its core, this case is about whether appellant Donald Smith forged a quitclaim deed attempting to obtain title to a home that he had rented from Ms. Smith and then refused to vacate. Contrary to the suggestion in counsel's argument, Mr. Smith never owned this home. He did have a rent-to-own contract that he had previously entered into, and at the end of that contract, he declined to purchase the home. Ms. Thomas then entered into a similar rent-to-own contract with the property's prior owners, the Swallows, and towards the end of that contract term, she purchased the property. Also, when she had entered into that rent-to-own contract in December of 2011, Mr. Smith, who had previously had a similar rent-to-own contract, expressly signed that contract confirming that he was giving up any rights he had, if any, by his prior contract. The trial court had ample reason to find that this quitclaim deed was as phony as a $3 bill. The deed was prepared by Mr. Smith and states, as this court has noted, that it was executed on February 3rd of 2012. Yet, in its property description, it cites the book and page number for a warranty deed that didn't even exist yet, and that wouldn't exist for another 2 years until July of 2014. The quitclaim deed also includes discrepancies in the notary stamp, including 2 different expiration dates. Mr. Smith claims he held on to this deed and didn't record it, as the Honorable Sweeney noted, because he didn't know how. Yet several years prior, he had recorded those 6 quitclaim deeds in Florida, and he knew how to do that. At the core, that's also why the trial court found that Mr. Smith was not a credible witness. This isn't a case based only on the testimony of the grantor. It's based on the phony deed itself, as well as Mr. Smith's lack of credibility as a witness. The trial court's findings concerning credibility are entitled to a presumption of correctness. Considering the record as a whole, the trial court found that the quitclaim deed was phony, was null and void, and that Ms. Thomas was the rightful owner of the property. We request that this court affirm the trial court's judgment. Now, counsel attempted to offer an explanation as to why this deed has these discrepancies. Again, none of this evidence was before the trial court. Now, as has been asked, no offer proof was made. The statement of the evidence is clear that none was made. However, in the subsequent hearing that we had with the trial court while preparing the statement of the evidence, the trial court was clear that he did not find Mr. Smith credible as a witness, and that if any additional evidence or additional witnesses had been offered, he would have been willing to consider that evidence. However, he was not willing to consider, after Mr. Smith had made a mockery of the proceedings by laughing and repeatedly misrepresenting circumstances under oath, to consider additional testimony from him. The trial court, especially in a bench trial, has broad discretion to admit or exclude evidence. Now, turning back to the deed itself, and I do have additional copies of the deed if the court would like them. The deed on its face has several discrepancies in indicia that it is phony. It was executed purportedly on February 3rd in 2012. It was prepared by Mr. Smith. I think we can all agree to that. It was not, however, signed by Ms. Thomas. It then was not recorded for 5 years because Mr. Smith didn't know how. The deed has no page numbers, and although it has a notary stamp, which Appellant's counsel has turned to suggest, well, this must be a valid deed because it was notarized. It has one notary signature and one notary stamp, but it has 2 different expiration dates for the My Commission Expires. Those are also in different handwriting. Of note, in Tennessee, a notary stamp only lasts for 4 years. So if this deed really was executed in 2012, how do we have a My Commission Expires date for 2018? And say, assuming we took the facts true that aren't in the record concerning he tried to remedy defects in the deed and went and had it notarized again, why are there not 2 complete notary seals on this? Appellant has cited in his brief authority that a deed can't be overturned based on the testimony of the grantor alone. That isn't this case, though. Now, Ms. Thomas has affirmatively testified several times that she did not sign this deed. She said Mr. Smith is known to forge documents. But aside from that, when the trial court had the opportunity to observe Mr. Smith's testimony and ask him questions on inconsistencies or things like, why'd you hold on to the deed for 5 years? Why are there different My Commission Expire dates? Mr. Smith did not have a credible answer. Again, this credibility finding is entitled to a presumption of correctness. And it is exactly why Mr. Smith was asked to step down. Finally, even if the deed had been executed in February of 2012 by Ms. Thomas, it would have been of no legal effect. Ms. Thomas had no ownership interest in the property until she received a warranty deed in July of 2014 from the property's prior owners. Accordingly, this falls into the line of one cannot convey something in which he or she has no interest. Mr. Appellant's counsel has raised several other issues, both in his brief and argument today, that have not been preserved. For example, the issue as to what additional evidence would have been proffered at trial after Mr. Smith was asked to step down from the stand. There's nothing in the record of any proffer of additional evidence. And again, turning to the transcript from the hearing on the statement of the evidence, the trial court aptly noted that there was no other witnesses that were ever submitted or offered. Additionally, the attorney's fees issue has been waived. Ms. Thomas, in her original petition, sought attorney's fees. Throughout the time through trial and then through the damages hearing, there was no motion to dismiss, no objection to them, and this issue was tried by implication.
What was the legal basis for the granting of the attorney's fees? Is there a contract, or what's the basis for that?
So the court's order does not expressly state what the basis was. The court's order states that the damages were for this hearing. However, we submit that under Tennessee common law, there is a basis when one has fraudulently recorded title or sought to obtain title that the opposing party may seek attorney's fees, essentially for the thought of they are having to spend the money to now go clear their title and have that clear chain of title. Additionally, we submit that there was sufficient evidence supporting the damages award. Under Rule 701 of Tennessee's Rules of Evidence, an owner can testify as to the value of her property. During the damages hearing, and of note, Mr. Smith was removed from the property and the writ of possession was issued only the day before the damages hearing. Ms. Thomas went in, tried to evaluate the property as best as she could from the condition it had been in when she had left the home after being threatened to and forced out of the home, and summarized for the court the damage to the property. There were additional photos that were not made exhibits, so we have not included those in the record. Among the damage she summarized was things such as missing appliances, leaks throughout the home, damage to the walls and floors. These are ordinary things that a person can go and look at their home and see, well, this is damaged. There's big gouges in the walls, or there's stains everywhere. This faucet is leaking, or all of my appliances are gone. The trial court specifically asked Mr. Smith again on some of these, well, the trial court or Ms. Thomas's counsel asked Mr. Smith again on some of these issues. And again, he was not able to provide a credible explanation for why the appliances were missing. Ms. Thomas initially requested damages between $11,000 and $12,000, and appellant's counsel had noted there were several things that she said were only estimates. In her testimony at the damages hearing, she noted that there were several issues that she was not yet able to get estimates on because of the short period of time. Ms. Thomas also was able to testify as to the amount of rent that had or hadn't been paid. Considering all of this evidence, and again making a credibility determination against Mr. Smith, the trial court awarded a conservative $8,000 in damages. It is well established that once the existence of damages are proven, less certainty as to the amount is required and generally shouldn't be overturned. Finally, turning to the attorney's fees issue, as I noted, the trial court awarded the attorney's fees specifically for that hearing. The trial court would have the ability to know, here's how long the hearing lasted, here's generally the reasonable hourly rate for attorneys in this area, and then awarded a conservative $1,000 in attorney's fees. Additionally, because of the circumstances of this appeal, including that Mr. Smith has not preserved an adequate record, has ignored the bulk of the evidence and provided only a bare bones summary of the facts and issues, his conduct during the proceedings below, including mocking the legal system and testifying falsely under oath, his failure to preserve several issues, and his attempt to again delay, drive up legal costs and fees to prevent Ms. Thomas from having clear title, we do also request that this honorable court award Ms. Thomas attorney's fees for this appeal under Tennessee Code annotated 27-1-122. Mr. Smith wanted Ms. Thomas's house. That's really what this case comes down to. After she agreed to let him stay there, since they did have a shared child, he then refused to leave. Instead, he threatened her, he forced her, and drove her out of her home, and then he attempted to wrongfully obtain title to that home by preparing the quitclaim deed we are here about today. The trial court had ample evidence to find that this quitclaim deed was phony as a $3 bill and was null and void. It observed and questioned Mr. Smith on 2 separate occasions and found that he was not a credible witness. Accordingly, we respectfully request that the judgment of the trial court be affirmed and that Ms. Thomas be awarded her fees and costs for this frivolous appeal under Tennessee Code annotated 27-1-122. Are there any questions I can answer for you all?
I hear none.
Thank you, Your Honors.
Thank you. We'll hear from you, Mr. Hall, on the rebuttal.
Thank you, Your Honor. I will be very brief. Number one, with regard to attorney's fees, to answer the judge's question, there is no contract, there's no statute that awards attorney's fees, so it would be very, very unusual for any award of attorney's fees to be granted. And again, there is no basis for that. There's nothing in the record that says somebody worked so many hours, somebody's rate was X amount per hour, or there was a flat fee even discussed. Nothing. That is very important for my client. And the damages issue, under the Rule 700 series, to suggest that the appellee testified based on valuation of the property is wholly unsubstantiated in the record. She tried to suggest what the cost might be or what she thinks the appropriate number was for work that was going to be done. She didn't say once, I don't believe in the record, anything about, well, the value of my property is lower now, and that's as a result of something Mr. Smith did. No valuation effort whatsoever. The appellee argues that, but it doesn't exist. And essentially, it's acknowledged, I submit, based on the argument, based on the brief, this appellee had no experience, no qualification to testify with regard to damages. As far as the cost to correct, there is no evidence in that regard. We'd ask that $8,000 be overturned and the $1,000 be overturned, and certainly any further relief that we've requested, we believe we've substantiated in the record. Thank you.
Court appreciates you, both counsel's argument this morning in your briefs. Thank you.